Good morning, everyone. This is George Lemieux with the Gunster Law Firm. I have the privilege of being the chairman of the board of the Gunster Law Firm. Thank you for joining us this morning. On the line with me and who will be presenting are several of my colleagues here at Gunster. Also joining us this morning is Bill Perry, our managing shareholder. Bill's been doing an excellent job of keeping Gunster up and running so that we'd be able to provide services like this to you, to our clients, and to our friends. So I thank him very much for all of his good work. Let me just start by saying that this is an extraordinary time for Florida, an extraordinary time for our country. We've never dealt with anything like this before, at least not in modern times. The good news is that in places where the pandemic started, life is getting back to normal, businesses are reopening, and we can look forward to that happening in our future as well. Vaccines and therapeutic drugs are not only being tested and innovated, but are actually being used now to treat patients. Testing sites in Florida are open in all major metropolitan areas, with more testing sites coming soon. In addition, American businesses are stepping up. Alcohol distillers are reconverting so that they can make hand sanitizer. Car makers are in talks to manufacture needed things like ventilators and respirators. And for the first time in many years, elected leaders are working together to solve the problems that are facing this country. And we'll talk more about that as the presentation continues. Americans are coming together as a people, and we know from our past that when Americans work together, there's nothing that we cannot accomplish. What I'd like to start off with this morning is to give the current state of affairs in terms of closures. This is a moving target, so let me tell you where we are as of 10 a.m. this morning. Most of you know that statewide bars and nightclubs have been closed by the executive order of the governor. Beaches have been limited to 10 people. In some municipalities, beaches have been closed altogether. Restaurants have been limited to operation around the state to 50% capacity with distancing of customers. In some municipalities like Fort Lauderdale and Miami Beach, restaurants have been closed for 30 days. More municipalities are following suit. Schools statewide are closed at least until April 15th. The court system is also closed for non-essential proceedings until March 27th, with some circuit courts like Palm Beach County extending that until May 1st. All civil jury trials are suspended until March 27th. Hearings are being done telephonically and by video. Cases can be filed, but those cases are not going to be acted on quickly with a limited court staff. Criminal cases and other emergency type matters are still going forward. We've had a big development in terms of the non-essential businesses being closed in Miami-Dade County. I want to talk about that order because that order is probably going to be a template for other communities in the state. Yesterday, Mayor Jimenez issued an order that closed all non-essential retail and commercial establishments. There are many exceptions to that order, and this order can be found as well as other information that we are providing for your use at our gunster.com website. Gunster.com/COVID19 has this order, as well as several alerts that we have put together for you that will provide information for your businesses on various legal aspects and business operations and techniques and advice for you concerning the virus. So in terms of the order, all non-essential retail and commercial establishments are ordered closed, except for healthcare providers, grocery stores and other food providers, people who are in agriculture, gas station and convenience stores, banks and related financial institutions, contractors, restaurants with the limitation exceptions that were mentioned before, and businesses that supply other essential businesses, airline taxis, professional services such as legal and accounting. There is literally more than 30 exceptions. So you should go to that order and look at it, even if you're not in Miami-Dade County, because that order is going to likely be a template and similar to what's coming in other places. Yesterday, the governor was in Broward County, and he indicated that he is going to issue an order for Broward County and Palm Beach County that is similar to the order that was entered into by Miami-Dade County. So be looking at what Miami-Dade County's done. We expect to get an order from the governor today for Broward and Palm Beach, and it is quite possible that over time that non-essential business order will be extended statewide. Many of you have heard that California has issued an order requiring its citizens to stay home. That order is actually very similar to the Miami-Dade County order closing non-essential businesses. It is not as draconian as it sounds in terms of ordering people to stay home. 16 essential infrastructure business areas, industry areas are exempted under the California order. The reason why I forecast that to you is that there's a potential that something like what's happened in California and something like what's happened in Miami-Dade County is not only going to happen in Southeast Florida, but eventually could be ordered statewide. I want to turn it over to my colleague, Luna Phillips, for a moment. She's going to talk about permit licenses and extension of time. Many of you have projects or developments that you are working on, and she can give you some insight on what might happen with those. And then I'm going to come back and speak about what's available for small businesses in terms of relief and what's happening in Washington. Luna, can you present to the group, please?
Yes, thank you, George. Can everybody hear me okay? All
yes.
Right. So in our team, our environmental and land use practice group, we have been monitoring any orders that have been issued by the Florida Department of Environmental Protection, the 5 water management districts here in Florida, the U.S. Army Corps of Engineers, and also the U.S. Fish and Wildlife Service. So as of right now, these agencies haven't issued any official orders, but they have put out some guidance. And these would be of interest if your business or your clients have any permits pending or have any timeframes or deliverables that are due to these agencies. In the past, what we have seen is during emergencies, these agencies will likely issue orders that provide extensions of time for permit durations or extensions of time to deliver required information to these agencies. And so it's very important to monitor these and determine if this is something that is of interest to you. And this would apply to any kinds of development projects, commercial, residential, if you have any marinas, docks, and agriculture. All of these agencies usually issue orders that might apply to these types of industries. We have been in communication with the agencies. They are still working. Their offices, though, are closed to the public. They are transitioning all their meetings, as are many agencies, to a webinar or teleconference and are posting notices on their websites. As we obtain these, we will also be posting them on the Gunster website. Of note, a couple things that we've seen, the Division of Administrative Hearings, which is the agency that holds administrative hearings for these types of regulatory permits and processes, has issued an order, and we're posting that on the Gunster website. And yesterday, the Department of Homeland Security issued a guidance, not an order, indicating various industries are critical infrastructure industries, and these include water, energy, wastewater, agriculture, and we'll be posting that online as well. So as of right now, these agencies are working. We are receiving emails from the Army Corps of Engineers. I've been in contact with the executive director of South Florida Water Management District. They are still working, although we can expect some delays in reaching the employees and some delays in turnaround due to the emergencies. Thank you, George.
Thank you, Luna. Before I go into the small business assistance, I want to turn it over to my colleague, Samantha Provkop, who's in our healthcare and corporate practice groups, and she's going to give an overview of the state of affairs on the healthcare side. Sam?
Thanks, George. Thank you, everybody, for attending today. So on the healthcare side, we've been in touch with healthcare practices and hospitals statewide. What they want to relay, we've even asked them specific things that they want us to relay to business folks. And what they've really told us is, first of all, they're not panicking. This is something that's going to pass. They are actually slowing down a little bit right now as far as the emergency departments. They're encouraging people to stay home unless you have a true emergency. If you think you have COVID-19 symptoms, do not come to the emergency department unless you can't walk, talk, or breathe, are what our emergency physicians are telling us. They're actually a little bit slow right now, but they fully expect that there is going to be a surge at some point, and that's what they're preparing for. And they also wanted to let everybody know leadership is key right now. On the business end, helping keep your employees informed as to what's going on, making sure people aren't panicking. Leadership is needed now more than ever. The third thing that they wanted us to let you know is that you need to promote that people stay at home. I know we're going to talk to Holly about some employment law changes during the call today. And there are going to be certain things that you may be tempted as an employer to get a doctor's note, require a doctor's note. And so the providers are really wanting people to know, to the extent that you don't have to send people into the healthcare system right now unnecessarily, please don't do so. As far as cleaning your business goes, you should be talking to your cleaning folks. And if you have employees that are coming into your office, make sure they know the term is terminally clean. Make sure they're getting doorknobs, copy machines, and things that are commonly used to help stop the spread. Right now, the biggest concern in healthcare appears to be supply shortage concerns. N95 masks are hard to get a hold of. Testing kits with the swabs are hard to get a hold of right now. So to the extent physician offices are closing down or elective surgeries have been canceled, those providers are actually helping supply the local hospitals. So to the extent that you have hand sanitizer, gloves, aprons, or anything that may be needed that you're not using, talk to your local hospitals and see if they need them. I know a lot of them are taking those supplies, purchasing them, or even taking donations if you have anything sitting around. And then finally, personnel. They expect that there's going to be a shortage. If anybody knows respiratory therapists in state, out of state, RNs and LPNs who can pass medications, as there is a surge here, they expect that those type of medical practitioners will be in short supply and will be needed. And then finally, just don't send your staff for testing unnecessarily. They're not testing everybody right now unless you have traveled to a high-risk country and are exhibiting symptoms such as shortness of breath, a temperature of 100.4 degrees, or a cough, a dry cough. They are not testing unless you have both of those indicators. You've either traveled and have the clinical symptoms, or you've been directly exposed to somebody who's confirmed positive and have clinical symptoms. So again, if you can just encourage your employees to stay at home, quarantine versus flooding the healthcare system, that'd be appreciated. And George, that's all I have for updates. I'll turn that back over to you.
Thank you, Sam. And let me just add on to that in several places around the state, there are mobile clinics that are now being set up at hospitals, usually in the parking lots outside. And if you want to go to one of those clinics under the recommendations that were just provided, you need to schedule an appointment. They are not just for you to drive up to or for your employees just to drive up to. They have to be scheduled. So I just wanted to add that. Let me turn now to business assistance. The state under Governor DeSantis has set up and activated the Florida Small Business Emergency Bridge Loan Program. That program is going to be administered by the Department of Economic Opportunity. It will provide short-term interest-free loans to small businesses that experience economic injury from the virus. The businesses have to be between 2 and 100 employees located in Florida. They will provide short-term loans at this point up to $50,000, and at this point $50 million has been allocated for the program. The loans are interest-free and would go for up to 1 year. They are designed to bridge the gap between what the Small Business Administration loans will provide. If you want more information concerning the governor's program, you can go to floridadisasterloan.org, floridadisasterloan.org, and you can apply for that loan at that website. On the federal side, Florida has been declared a emergency area. That just happened yesterday. That means that Small Business Administration loans are also available. Those loans are up to $2 million. They can be used to pay debts, payroll, accounts payables, or other bills. They have to be because of the disaster's impact. Interest rates on those loans are 3.75% and 2.75% for nonprofits. To find out more information and to apply for a small business administration loan, go to disasterloan.sba.gov/ELA, disasterloan.sba.gov/ELA. I want to turn now and talk about what's happening in Washington in the United States Congress in order to pass relief bills. Holly Goodman in a moment is going to talk about some of the aspects of the bill that was passed earlier this week as it affects employers and employees. There is a third piece of legislation that is being negotiated right now. It is called the CARES Act. It is a $1 trillion, perhaps more than $1 trillion relief legislation, 247 pages as reported. That legislation will provide, and again, this has not been enacted, this is still being negotiated. It could be changed in the negotiations between Senate Republicans and Senate Democrats, as well as negotiations between the House and Senate. But as of now, it has a $1,200 stipend that will be sent to individuals, $2,400 per couple. That will only apply to households that are below $99,000 for individuals. I should say income thresholds at $75,000. It will start to graduate down and for $150,000 per couple. And then when you get to $99,000 per individual or touching $200,000 per couple, people will not be eligible. There also are supposed to be payments of $500 per each child. Again, this is a fluid situation, but that's what's being discussed. The bill also contains $300 billion to small businesses that would provide loans that would eventually be forgiven for employers who use them for payroll expenses. This is a focus of keeping people working. So the loan would be tied to not letting workers go. Senator Marco Rubio, is the chairman of the Small Business Committee in the Senate. He is shepherding this provision. He has said that the loans would be issued through banks, credit unions, and other private sector financial firms to speed the process of distributing funds. Businesses would use the loans to keep workers on their payroll, pay their rent, or handle other necessary expenses. That's a critical part. And again, that could be up to $208 billion of loan relief. There also is $50 billion for the airline industry, $8 billion for air cargo carriers, and $150 billion that's been designated for other eligible businesses. We don't know yet what those businesses would be. The legislation also includes provision that would defer payments on the 6.2% employer payroll tax. Also included in the legislation would be a requirement that insurers provide the coronavirus test free, and that all vaccines would also be offered free to patients. Again, a lot more will be happening today, potentially over the weekend or Monday, to get that legislation passed. A lot of relief coming from the federal government. Let me turn it over now to my colleague, Holly Goodman, who practices in our employment law group. Holly's going to give an update on the legislation that's already been signed into law by President Trump and how it affects employers and employees.
Thank you, George. Good morning. Obviously, the big news this week in the employment space has been the bill for the Family First Coronavirus Response Act and the implications that it has for employers on paid leave requirements. The president signed the bill into law just Wednesday night. It is expected to have an effective date of April 2nd, 2020, so we are currently in a time period when employers should be looking at their policies and figuring out how it is that they're going to implement these new provisions. There are two provisions that primarily are going to impact employers. The first is a sick leave requirement, a paid sick leave requirement. It applies to all employers that have fewer than 500 employees. Those employers are going to be required to offer paid sick leave to employees if the employees themselves are experiencing symptoms of coronavirus and are seeking a diagnosis, if the employees have been subject to a self-quarantine order by a healthcare physician, or if the employees have been subject to a self-isolation or a self-quarantine order by a local official or federal state official. It also applies, or employees can also use it if they're going to be taking care of an individual who is under a self-quarantine order by the federal, state, or local government. If the employee is taking care of a minor child and is unable to work, then they are taking care of a minor child who is out of school because schools are closed or because their daycare is closed, or even if the employee is experiencing symptoms of a similar illness that the Department of Health and Human Services will have to identify. Now, for an employee to be able to use this paid sick leave, the employee does have to be unable to work or telework. So if employees are still able to work from home while caring for another who's under self-quarantine, while caring for themselves, or while caring for a child who's out of school, then the employees are not entitled to use the paid sick leave at that time. They can be required to telework and work from home if they're able to do so. The Act has some nuances on how much the employees are required to be paid. So full-time employees are entitled to 80 hours of time off. Part-time employees are entitled to 2 weeks' worth of their regularly scheduled hours. The amount to be paid varies depending on whether the employee is taking care of themselves because they have been ordered to self-isolate by either a physician or by a government official, or if they're taking care of themselves because they are experiencing symptoms and they are seeking medical care or a medical diagnosis. If they're using the leave for themselves, then the employee should receive their full rate of pay, but there is a cap at $511 per day or $5,110 per employee in the aggregate for their 80 hours total. If the employee is using that paid sick leave to care for another or to care for a minor child, or because the individual is experiencing similar symptoms but does not have a COVID diagnosis or has not been seeking medical care, then the pay is at 2/3 of the employee's regular rate of pay, with a cap of $200 per day or $2,000 in the aggregate per employee. In addition to the new paid sick leave requirements, there is also now a new extension to FMLA. So FMLA traditionally has not applied to employers with fewer than 50 employees. This new extension of the Act applies to all employers with fewer than 500 employees. The Department of Labor has the authority under the Act to issue regulations to limit or accept employers with fewer than 50 employees if compliance with this new provision would jeopardize the business as a going concern. So we are still waiting on the Department of Labor to issue those regulations to identify how it is that employers with fewer than 50 employees will be exempted. The FMLA extension will require employers with fewer than 500 employees to offer family medical leave to employees who have worked for the company for 30 days. So it's no longer the 1-year restriction typical under the FMLA, but for 30 days. But the leave only applies to employees who are unable to work or telework because their minor child's school or place of care has been closed. The leave is unpaid for the first 10 days of the leave. The employees may be permitted to use other forms of paid leave, including the paid sick leave. After that first 10 days, the remainder of the leave, up to the 12 weeks total for FMLA, is paid at 2/3 the employee's regular rate with a cap of $200 per day or $10,000 in the aggregate per employee. So these are significant changes in our leave laws because they do require additional paid leave for employees. The one last thing that I will caution employers about before we get into the next portions of our presentation is that while the focus right now is on this new Act and new obligations, employers should still be keeping in mind existing laws that apply to their employees, including the Americans with Disabilities Act, FMLA as it existed prior to this new bill, as well as wage and hour requirements, and making sure that you are properly paying your employees when the business is operational. So if anybody has any questions, we do have our Q&A going, and we'll get to those, as many of those as we can today. But for now, I will turn it back to George.
Thank you, Holly. And for those of you who do want to ask questions, you can submit them in your chat box. We're accumulating those questions now, and we will get to them when the presentation is over. Next, I want to turn it over to Asghar Syed. He's in our business litigation group, and he is going to speak about contract provisions, force majeure clauses or act of God clauses, and cancellation of events. Asghar?
Good morning, George. Can you hear me okay?
We can hear you fine.
Thank you, and good morning, everybody. So a force majeure provision may excuse a party's contractual non-performance or delay under certain extraordinary circumstances. I saw in the Q&A earlier a question came in about commercial leases and force majeure there. In the interest of time, my comments here are going to be generalized and applicable to that question, not industry specific, but they'll sort of lay the groundwork and we can get into specific industries as we go. So I'm going to quickly touch on how courts interpret and apply force majeure provisions. I'm also going to mention, but not get into any detail, on common law and statutory provisions that run parallel to this concept of force majeure. The big picture here is we're talking about a case-by-case analysis. It's highly fact-intensive, and the outcome at the outset can be rather unpredictable. So before we get into the weeds, let me make three, I think, practical points. It's important right now for us to be reviewing our material contracts, identifying the force majeure provisions, evaluating whether or not we think that they're any good, and considering who's likely to assert them, us or our contract counterparties, and getting prepared for that. In the last week or two, to the extent these issues have been coming up, our clients have not been asking us to engage in brinksmanship. The order of the day has largely been to take what is a very uncertain and open-ended scenario and try and negotiate for a mutually agreeable and predictable arrangement with our contract counterparties. So that's really a lot of what's going on today. As I think you'll pick up on as we get into the details on these provisions, if you have absolutely no other options, if you're in a situation where you think you're going to be relying on a force majeure provision, it is important to clearly document your efforts to mitigate against that non-performance or delay. So then let me get into my 2 points. The first is, how do courts interpret and apply force majeure provisions? An asserting party must show that the event is 4 things. First, that it qualifies as a force majeure under the contract. Second, it's not foreseeable. Third, it could not have been avoided. And finally, that event is the sole and proximate cause of the non-performance. Now, what I read is the prevailing law in Florida. So one of the things that we want to do when we're reviewing our contracts is determine what law applies. The standards may be different. There are nuances from jurisdiction to jurisdiction. We want to be very sensitive to that. So the big question that people are asking right now is whether COVID-19 is a force majeure provision under their contract. Force majeure provisions are narrowly construed. The prevailing law says that the force majeure event must be specifically identified in your contract. And so if your contract force majeure provision includes the words pandemic or epidemic or disease, you may be well positioned. Many force majeure provisions will make references to government action, travel, movement, large gathering restrictions. These two may be applicable. A common phrasing in force majeure provisions that at this moment in time there's not a very clear answer on is acts of God. Is COVID-19 an act of God? In Florida, there's no binding authority. There's good arguments to be made either way. And litigants that are in a position where they have to assert force majeure provisions and all they have to go on is the phrase acts of God will almost certainly make those arguments. In 6 months to a year, as these issues are working their way through the courts, we are likely to have a lot more clarity, but that clarity doesn't exist today. One final point on the way that your force majeure provision is stated. There are oftentimes closed-ended force majeure provisions. They have a definitive list of events that can constitute force majeure. And in other cases, you'll have an open-ended contract. It'll say that a performance is excused based on unforeseeable, unavoidable events, and then it might provide a series of illustrative examples. Those open-ended contracts shouldn't give you too much assurance, or you shouldn't have a false sense of security with those open-ended contracts. Oftentimes, courts will interpret those to still be limited to the specifically identified events, or with some catch-all language, similar events. It doesn't mean that simply because an event is unforeseeable and unavoidable, it would necessarily constitute force majeure. One final point on contracts. As we're evaluating them, we want to be thinking about procedural requirements that are raised by the contract, notice provisions, other conditions precedent to asserting force majeure. So the second element that I talked about earlier was that the event must be not foreseeable. In March of 2020, I think that there shouldn't be too much dispute that COVID-19, as we're experiencing it today in the United States, was not foreseeable. As time goes on, though, that analysis could change. In October 2020, we might look at that question differently. The next is that the event could not have been avoided. What's important to note here is that parties have to perform to whatever extent they are able. They have a duty to mitigate. And along similar lines, what's clear in the law is that economic hardship is not sufficient. A party asserting force majeure really wants to be able to demonstrate an impossibility. It wasn't that the event caused their performance to be not profitable or a bad idea. It must be not possible. The final point is causation. Is the event the sole and proximate cause? This is a high standard. And if your counterparty in litigation can point to other causes of non-performance, like a material shortage, they might be able to overcome your assertion of force majeure. There are substantial risks to taking these positions and getting it wrong. It can be argued that you have anticipatorily breached your contract. The asserting party bears the burden of proving that they had met all of the elements of force majeure. And so we have to proceed very, very cautiously if, in fact, we have no other options but to rely on those provisions. The final point that I was going to make about the scenario where your material contracts or your relationships don't have a force majeure provision, there are concepts in common law that might be applicable where there's not a controlling contractual provision. Florida law recognizes impossibility and impracticality. It also recognizes a distinct concept of failure of purpose. And so not having a force majeure provision in a material contract is not the end of the analysis. There are other questions that we need to ask and look into. With that, I'll turn it back over to George.
Askar, thank you very much. Our last presenter today before we take questions is Stephen Richmond. Stephen's in our business litigation group, and he's going to talk about issues concerning insurance. Stephen?
George, hello. Can you hear me?
Can hear you fine. Thank you.
Okay, perfect. Thank you, ladies and gentlemen. As George mentioned, I'm going to talk about some of the insurance issues arising out of the COVID-19 crisis. This is intended to be a broad overview. Certainly, individual businesses may have additional insurance policy and coverage issues, and that is why, just to give you a preview, one of the takeaways from my portion of the presentation is to gather your policies, understand what coverages you have, what coverages you may not have, and discuss the same with your agent or your lawyer if you perceive any losses or intended losses. My second takeaway, and I want to visit these at the beginning because I think they're the most important, use this as an opportunity to review your entire risk management portfolio with your agent or broker. You're not going to be able to go to an insurance company and buy coronavirus protection now. Insurers are not going to write that risk now, but I think this is a good opportunity to evaluate what you have, what you don't have, and it's particularly important to understand what your policies say. That is the theme underlying my entire presentation today, is that policies are different, the language matters. So let's talk about some of the insurance issues that have arisen. Business interruption and contingent business interruption coverage. For business interruption coverage, think of a fire loss to your property that you cannot operate your business. Generally speaking, you need to have an actual direct physical loss or damage, a reduction in net income, and there's a period of restoration. One of the issues that I anticipate being heavily litigated is whether or not the coronavirus is an actual direct physical loss to a property. I think that's going to be a difficult burden to overcome based on current case law, but that will be one of the main issues addressed. Contingent business interruption coverage generally is going to be if you have a direct supplier who's unable to meet their commitments to you. But please be aware, this is not the first time that these types of issues have arisen. In response to the SARS episode, the Insurance Services Office released a virus exclusion that was attached to some policies that has also been approved in some states. If your policy has that exclusion, it may be very difficult to obtain coverage for business interruption. Event cancellation policies. There must be a legal or physical impossibility to hold the event. Voluntary cancellations or beliefs that people may not come likely are not going to be sufficient. You must try to reschedule. In these insurance policy and coverage issues, there is a duty to mitigate in good faith, and that's where on an event side, rescheduling is going to be something to look into. And event cancellation policies may have a communicable disease endorsement. Touching on briefly on workers' comp claims, there's typically a work-relatedness requirement. And so what that essentially means is you can't just get it at work. It has to be related to the work that you are performing. If you have a loss or if you anticipate a loss, notify your agent. Don't forget about umbrella or excess policies if the loss or the perceived loss is large. We have already seen litigation filed. A lot of media coverage. There's a lawsuit pending in Louisiana State Court, business interruption coverage against some certain underwriters at Lloyd's of London. As I mentioned, in the past, pandemic coverage has been available, but insurers are not going to be writing that right now. A couple other significant state responses, some somewhat unprecedented things we have seen. Nothing yet out of the Florida Office of Insurance, but in New Jersey, their state government has proposed a law to essentially require property and casualty insurers to provide COVID-19 coverage despite language in the policies excluding such coverage. That bill has not gone to a vote or hasn't gone to the floor. And the coverage that I've read has suggested that insurance industry leaders are discussing the matter with the New Jersey politicians. I would think there would be some significant constitutional problems with the proposed legislation. In New York, the New York Department of Financial Services has issued a directive to property and casualty insurers to send their policyholders explanations of the coverages provided under a business interruption endorsement or policy. That's fairly unprecedented as well, since it was seen that the directive is requiring the insurers to take a position on potentially covered losses without knowing the underlying facts. Again, this is going to be an extremely fact and policy language specific review. So read your policies, gather them, understand what insurance you have, and use this as an opportunity to evaluate your risk management portfolios. Thank you.
Thank you, Stephen. 2 points that I want to make before we open things up for questions. One is, as I mentioned before, at our website, gunster.com/COVID-19, we have several alerts. One area that we did not cover today, but we have an extensive alert on, is immigration. It deals with visas, travel, everything from designated airports where people can return to from overseas, State Department declarations. So if you have immigration questions, there's a lot of information that's provided at gunster.com/COVID-19, as well as on the issues that we presented on today. We're going to start with our questions. I want to say before we get to the question portion that this presentation is being recorded, and it will post on our resource page for people who are not able to attend today live. You are feel free, please, to share this with other people. You'll be able to forward this presentation, and you will be able to find that again at gunster.com/COVID-19. Additionally, the questions are coming in now. We're not going to say who the person who's asking the question. I'm just going to go through the question and get them to the right person here on our team to answer them for you if we can. So let me start with a question about will Florida remove wait week requirements or increase weekly benefits to employees who've had to be laid off because of closure? So I think, Holly, this is for you. Is there going to be any benefits that are going to be extended? And we know now, Holly, that there are some unemployment opportunity benefits for people who are laid off. Can you speak to that topic?
It is possible. So there are some states that are talking about limiting the waiting requirements for employees who are laid off as a response to the current economic crisis. And part of the Family First Coronavirus Response Act actually included significant funding from the federal government to state agencies in order to assist with responding to unemployment compensation claims. So Florida has not done that yet, but it is something to keep an eye out for.
The next question is for Sam. The question is, what is the definition of a healthcare worker under the new law? Does this include healthcare workers at primary care clinics, including FQHCs?
So good question. Right now, what we're relying on is the current FMLA definition of a healthcare provider. So it's kind of broad right now. It includes for sure MDs and DOs. And then any other person determined by the Secretary of Labor as being capable of providing healthcare services. So that's kind of open-ended. That has not been determined. So what we're waiting on is we think the Secretary of Labor will probably end up issuing some type of rule. The formal rulemaking authority's been process has been waived. So we expect some more guidance from the Secretary of Labor as to what type of healthcare workers may be exempt, because we understand that's a huge problem right now. Home care, we're getting a lot of questions because if these employees were not exempt and then could be stayed home and had to be paid, it could really, really cause some huge healthcare shortages for providers that are not just MDs or DOs. So we're waiting for more guidance right now. Stick with MDs, DOs, and then we will wait to see if we get a more specific definition in light of this coronavirus issue right now.
Thank you, Sam. The next two questions I'm going to put together and try to respond to. One is, do employees of essential businesses in places like Miami-Dade County where non-essential businesses have been closed, do they need some sort of certification form when traveling to and from work? And another related question, is there a formal document or approval process to allow essential workers' businesses to remain open? Right now, there are no such papers that have been issued or granted. I do not think that police forces are going to be checking people to see whether or not they have proper paperwork to go to a business. We just do not have the resources to do that in our cities and counties and here in Florida. It's going to largely be enforced upon us by employers, that employers are going to only stay open if they meet the definition of essential, and that employees will follow the direction of their employers. So it's incumbent upon all of us as employers to follow the rules so that we can make this work, so that we can stem the spread of the virus. We got a question concerning the force majeure clauses, so I'm going to let Askar answer this. The question is, are you seeing landlord and tenants in commercial leases starting to apply these force majeure clauses?
Thanks, George. There's certainly a lot of attention being given that issue. I know the folks in our real estate department that work on commercial landlord-tenant leases have been very, very focused on that issue. We've been dialoguing about it. The big point here is it's case-by-case analysis. It's really going to depend on the precise phrasing of the contract, but it's also going to depend on how the parties to that contract approach this issue. If the performance at issue is the tenant having to make a payment to the landlord, is the ability to make that payment to perform in that way really undermined by any of the items that are listed in your force majeure provision? There's certainly an argument that it's not. The other principle that comes in here is that the fact that an event has rendered performance economically difficult or not profitable does not trigger the force majeure provision. And so a tenant may still, under that reading, be required, even if it's extraordinarily onerous or not profitable, to fulfill their payment. The thing that's happening right now is that parties are negotiating. The force majeure provisions in many instances are becoming the backdrop to parties trying to find mutually agreeable resolution. If a tenant was to claim that they are relieved from any of their obligations under the force majeure provision, and they make absolutely no effort to mitigate their damages, they make no effort to try and negotiate some kind of partial payment or delayed payment, they're going to be in a difficult position if down the road they're trying to assert force majeure in court.
Thank you, Askar. We're getting lots of questions about what an essential business is. Again, the only place in only place in the state of Florida right now that has a prohibition on non-essential businesses being open is Miami-Dade County. We understand from the governor's remarks yesterday that Broward and Palm Beach are going to be ordered by the state to do that as well. The only template that we have as of 10:50 this morning is the order that was entered by Mayor Jimenez, which you can find on our website at gunster.com/COVID-19. That order says all non-essential retail and commercial establishments are ordered closed, but there are 30 categories of exceptions for healthcare providers, grocery stores, and other folks in the food business, agriculture, gas stations, auto supply, banks, contractors, shipping services, private colleges, restaurants with the limitations about being 50% full and not spacing people next to each other. And again, on restaurants, some cities have shut down all restaurants for 30 days independently of this order. Business, but I want to make a point. We got one specific question is, if I'm a landlord, can I keep my site open for the safety of residents and to protect my property? One of the exceptions in the Miami-Dade County ordinance, which we believe is going to be a template order for the rest of the state, is under sub O. It says businesses that supply other essential businesses with support or supplies necessary to operate and which do not interact with the general public. So the answer to that question, at least for Miami-Dade County, in my view, would be yes, you would be able to stay open. Also, airlines, taxis, trucking, busing, professional services such as legal, accounting when necessary to assist with compliance with the law, child care facilities. Again, go to our website, gunster.com/COVID-19. You can find this order. It is now only the order for Miami-Dade County, but we believe, based upon the governor's remarks yesterday, that it's going to be the template for Southeast Florida, and would not be surprising if this were not applied to the rest of the state of Florida. Let me answer other questions here. Are there any measures being considered by Florida to provide temporary or permanent relief, such as those being considered by Congress? Yes, the governor said this morning that they are looking at ways that they can help businesses with financial relief. There's also, you might have seen around the country, that different mayors and governors are suspending the ability of landlords to evict tenants or enforce leases against tenants who do not pay. A certain 90-day to 120-day moratorium has been done in some places around the country. The governor said that he was looking at that as well. So we'll have to wait to see what happens from the governor's office. There was a question about how does this affect a nonprofit organization? Nonprofit organizations are impacted just like for-profit organizations. You have to look at the order to see whether or not your business falls within, but if there's not an exception for the type of work that you do as a not-for-profit, then you will be ordered closed. If, for example, you are a child care facility that's not-for-profit, you will be able to stay open, at least under the Miami-Dade County ordinance. So looking at the ordinance and whatever comes out as an executive order from the governor's office will be very important. Additional questions that we have. We have a question, I think this is for Holly. The information yesterday that was sent out about the Coronavirus Emergency Response Act has been signed by the president and goes into effect April 2nd. Is that correct? We have employees who are in that position today. What processes are involved for employers to honor those benefits today? What documentation should employers require? Holly, can you try to tackle that?
I can, yes. So the Act itself says that it will go into effect within 15 days of its execution by the President. Our sources within the Department of Labor are telling us that that will be the April 2nd date. They will take the 15 days because the Department of Labor is still working on regulations to give guidance to employers on how to implement these provisions. That should also be forthcoming soon. In the meantime, while the Act is not in effect, employers should be aware that anything that they do over and above their existing policies will not get them the benefits of the Act. So if you are giving employees additional sick leave right now, those employees will still be entitled to their paid sick leave requirement come April 2nd under the Family First Coronavirus Response Act. And any of the voluntary leave that you are giving between now and the effective date of the Act, if it's not satisfying the criteria of the Act, will not get you the tax credits either. So that is something to keep in mind as employers are planning what additional measures they want to take for their employees or if they want to give them any additional leave.
Holly, a couple more questions. If employers are able to work from home, however, the business has to shut down temporarily due to lack of work, would either of these two new laws apply, the Emergency Paid Sick Leave Act or the Emergency FMLA Act?
Whether or not the leaves are going to apply if a business has to shut down temporarily because of the current economic crisis is an issue that we expect the Department of Labor to issue guidance on next week. At this time, our best reading of the Act is that if a business shuts down completely because of a lack of work and there are no employees able to work, then employees would not be entitled to these benefits because the benefits apply when an employee is unable to work because of one of the enumerated reasons. And if an employee is unable to work because there is no work and the business is closed, then presumably these will not apply. But we are waiting on additional guidance from the Department of Labor, which we expect to come soon.
Thank you, Holly. The last question I have is on force majeure. So Askar, if you could get ready. The question is, if a company is entering into new contracts in April and going forward, would it be wise to modify the force majeure clause in some manner, such as to specifically add COVID-19 as a force majeure event and specify that it's still included even though the parties had knowledge of it when the contract was signed?
Thanks, George. Yes, the answer to the question is absolutely yes. You want to be as specific as possible. Today, entering into these contracts, we would very much want to include the words pandemic, epidemic, disease, and it would be a very good idea to also specify COVID-19.
Thank you, Askar, and thank you to all of my Gunster colleagues, Sam Propkoff, Luna Phillips, Holly Goodman, Askar Saeed, and Stephen Richmond for being on the call this morning. And thank you all for participating. These are challenging times. We are going to get through it, and we'll do that by working together. We have this information for you at gunster.com. I'm told it's not /COVID-19, it's /COVID-19. You can find that on our website. In addition, a recording of this webcast is available on our microsite that I just mentioned, COVID-19. And you can continue to submit questions there, and we will monitor them. We will be addressing your questions in upcoming alerts. So I encourage you to subscribe to our COVID-19 alerts via our website. In addition, if you have any questions concerning these matters as they apply to you or your businesses, and you would like a Gunster lawyer to help you with that, you can email me at glemieux, L-E-M-I-E-U-X, @gunster.com, or call me at 954-468-1339, 954-468-1339. Thank you all so much. Good luck. Be well. Take care of your employees, and we'll speak to you soon.